This is a collage of documents that was submitted for evidence for a formal hearing. Not one of them showed up. Those that did was not discussed in the context. So this video is the clips from the tail end of a formal hearing as well as a status conference call.
And the last thing I'll ask is that he does ask for opportunity to respond to our evidence, and I don't know how the commission wants to handle that, because this could go on forever through emails and responses. This was the time certain for the taxpayer to present his rebuttal evidence, and I think the commission should close the evidence portion of the hearing at this time. And that would be my motion.
And we'll grant that motion and close the record. We'll take the information received under advisement. The commission will issue a written decision, and that decision will include appeal rights available to either party.
All right, thank you for your time, and I'm sorry it was complicated, but the Zoom did help, so I appreciate that.
Thank you.
I will go ahead and stop the recording now.
Bodley and Watcott basically lied about the improvements made. Geez, if you go back, well, it gets very personal. It gets very personal. When I was denied any objections, Bodley motioned to close the case. Everything that I had submitted for the hearing, I have proof that it was submitted, didn't show up.
These personal attacks are going to just put you way far behind with me. Way far behind. And so,
well, you're an administrative law judge, right?
Yes.
You're also an attorney. You're also an attorney, right?
That is correct.
Well, then let's abide by the laws. You know, another law that doesn't make sense is in 59-2-106, the last paragraph says the commission shall decide all appeals taken pursuant to this section no later than March 1st of the following year for real property. So these matters 2020 should have been decided last March.
And we, of course, cannot do that because we need a decision on the 2019.
Well, that's where it just gets more confusing when you have to file for reconsideration. They denied it without any logical sense to it. Everything I submitted cited why it should be reconsidered. It was an impartial. It was a very impartial hearing by Canon Rule 2.2. I was dumbfounded that Commissioner Cragen agreed with Bodley's motion to close the case. That should have been taken under advisement.
I have good news for you. When you go to district court, it's a brand new hearing. You present brand new evidence, anything you want to present, and you just present your case there.
And that's exactly why I did it.
All right. Well, it sounds like we're all in agreement then. We can't do anything with the 20 and 21 just yet. And so what we better do with those is just give you time to work your way through the district court.
Sorry, Your Honor, I do need to clarify that. No, I didn't realize that was on mute. No. So the 2019 is final as a matter of law. He did not timely file it anywhere. And he did file it late with the Supreme Court and the Court over the Court of Appeals, and they issued a final decision.
They excused it because I was late, not by anything of evidence, damn. Let's go by the evidence.
So
That
Your Honor,
excusal is not even related to a civil court hearing.
So, Your Honor, I don't, he can file as much as he wants regarding 2019, but it's done. And I'm happy to submit the Court of Appeals decisions. But that's over, so we need to move forward to 2020 at this point and just have a hearing on that. I'm sorry I was on.
You'll have a chance to get up to court and explain why you saw the evidence 51 days before the Zoom hearing, the only changes for it. That was sent directly to you from Ephraim Olson.
So we'll certainly hear whatever evidence he's got for 2020.
You're gonna hear evidence for 2019 in district court. You already were served notice. I'm not gonna put up with all your baloney anymore.
That's fine. Let's look for, Mr. Keogh, do you have a current filing with the district court that will give you a decision on this?
It has not been filed. By the letter of the law that I filed it, it's good for 2 years. There's no deadline once you give them the 60 days notice.
So Your Honor, and I'm sorry, Your Honor, I don't mean to make this more difficult than it needs to be. He's referring to a notice of a governmental claim under the Governmental Immunity Act. Like if you have a tort or something, you have to send notice to the government first, and then before you could file a district court. That has nothing to do with an appeal of a tax commission decision. That is clear. You have 30 days.
It's obvious you don't want the case to be heard bodily. It says you submit a brief why the case should be heard. The brief I sent was 24 pages long.
We just need to move on to 2020, and he has every right to make the arguments he wants to that tax year, and he's kindly preserved that appeal before the commission, and I think you just need to schedule a hearing.
Okay, well, we have today's scheduled for 15 minutes, and we used up 14 of it. So what I'm going to do is I'm going to schedule this for a hearing. We can either have an initial hearing or a formal hearing. And Mr. Keogh, you have every right to make these arguments there if you'd like. That way we'll have time to hear them.
You'll have a chance to argue 2019. Do not file a date for a formal hearing with the tax commission.
Okay.
This is even crazier. When we had a status conference call on May 26th on the commercial property, I told all the parties that I would take that to civil court too. And what did Jane Fan do? She started a formal hearing for it. So I'm right on the cusp of serving notice to take that to civil court too. You did not listen to what I just said.
I heard you, and but I don't agree with you.
Oh, so
you have a right to be heard.
You're okay with an unbiased, impartial hearing? That's what 2019 was. We need that for 2019. 2019 in district court will be an impartial hearing. And Bodley and Watcott can get up there and explain why they feel like they should jack up the house $130,700 because I remodeled the master bedroom. That is not a qualifying change by the face of the law.
All right, well, I do need to move on to another matter. And so I'm going to do that, and I'll send notice of the next proceeding, and we'll have more time for that one. My apologies that I do have to cut the parties off today, because I really do need to move on to another hearing. So I'll set this for an initial hearing, and I'll give sufficient time for that. All right, thank you, Your Honor.
And the case will be filed in district court in the next couple of days.
And we'll talk about that at the hearing time. Thank you all.
All right, thank you.
This whole thing's a joke.
Everyone else has left the call.
What a joke. The appeal process is likened to a rodeo ride. You present your evidence, you're on top of it, then they knock you down. You get back up, down, deny, deny, deny. That's how they get their way. Just continue to deny you a fair and impartial hearing, and the burden of proof is on the petitioner. They're presumed to be correct unless you prove otherwise. So they do not want to have a trial in civil court because they will not prevail. They'll do whatever they can to stop you in your tracks. So I am going to take this. They've already been put on notice. Now I'm trying to find an attorney that's not afraid of going up against the government coup operation. So hang on, we're going to take you for a rodeo ride, folks.